Hello, my name is Rob, and today I will talk about a court case related to environment in Ontario. This is um, a big court case, or significant court case, known as Mathur v. Ontario. There is a press release from EcoJustice which says court sides with youth in historic climate case against Ontario. And this was posted on October 17th, 2024. It says the Court of Appeal ruled in favor of the youth-led climate lawsuits against the Ontario government. And it says that 7 Ontario youth are celebrating a victory by the province's court. They confirmed that Ontario must conduct its climate response in accordance with high standards of the Charter, and it says that a new hearing has been ordered. And they are optimistic, and the decision, this is from the press release, comes at a time when there's more direct impact being felt with deadly heat waves, catastrophic forest fires, and other climate-caused disasters becoming near regular occurrences. Last year, there was massive forest fires. Heat waves have occurred almost every year. And the forest fires from different provinces were felt in Peterborough, Northern, Kingston, Cattarauqua. I'm recording in Kingston, Cattarauqua, and this is being broadcast on Peterborough, Northern. In Peterborough, Northern, this is being taped. And yeah, there's been like 2 hurricanes recently, Milton being one of them, both heading the Florida area. And then it's saying that going back to the press release, there was a disproportionate impact on youth, indigenous communities, and nations. And it says that the court's ruling is an affirmation that the Charter applies to Ontario's climate targets and confirms that the government actions are harming Ontarians. And this is a precedent-setting case. And then there's a growing number of climate litigation cases around the world, with the United Nations Environment Program and the Sabin Center reporting the total number of those cases has more than tripled since 2017 and continues to grow worldwide. I will look at some of the other cases in less detail. I'll look at news articles about them. And then it says Germany, the Netherlands, and Colombia are increasingly ruling that climate change poses an courts around the world, including those countries, are increasingly willing that climate change impacts human rights, and they're ordering governments to set science-based reduction targets. And I might get into that. Some of the other cases, depending on how much time I have left. But I'll switch to the next article. Should make a new transition screen. I'm just switching to the court case because I'm also showing this episode on YouTube. So this is the court case, Mathur versus Ontario, Mathur, 2024. There's been other cases since before this, which is why this is an appeal. It mentions the seven litigants or appealants. And there's intervenors. And then the court case goes through different sections. There's the overview. Each paragraph is numbered. So in the overview, it's saying that this appeal involves the constitutionality of the greenhouse gas emissions reduction target and plan enacted by the Ontario government under climate change legislation, and that there was an alleged failure of Ontario to comply with its voluntary, and this is a key line in the court case, impose statutory obligations. So the statutory is legislation to combat climate change amount to a breach of the appellant's Section 7 and 15 rights under the Canadian Charter of Rights and Freedoms. And I will go to the Canadian Charter of Rights and Freedoms. So section, am I able to, okay, I enlarged, might be able to enlarge it. I'm just finding section 7, which is the reference. So everyone, section 7, everyone has a right to life, liberty, and the security of the person, and the right not to be deprived thereof, and except in accordance with principles of fundamental justice. So I did read about fundamental justice as well, so I might go into that when it comes up. So that's section 7. And then section 15 of the Canadian Charter of Rights and Freedoms is every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, uh, national or ethnic origin, color, religion, sex, age, or mental or physical disability. And so those are the two sections that are referenced in this case. So I'll go back to the case. So I'm back, and it says in 2018, Ontario enacted the Cap and Trade Cancellation Act, and in the rest of the document, it's called the CTCA. The target Ontario said is labeled preserving and protecting our environment for future generations. A Made in Ontario environmental plan. It said that this is a much smaller reduction than prescribed under the Climate Change Act. And according to the Climate Change Act is either previous legislation. They repealed the Climate Change Mitigation and Low Carbon Economy Act. And this target was lower than the previous target. And then the evidence was unchallenged by expert evidence, and it falls short of international scientific consensus for the reductions recommended to mitigate the most catastrophic effects of climate change. They want a declaration that sections 3 and 16 of the CTCA are unconstitutional. And I'm reading in paragraph 3. As they violate the rights under subsection 7 and 15 of the Charter. They want Ontario to set evidence-based decisions on climate change based on international standards. And in section 4, the application judge dismissed the application, but concluded that section 7 and 15 charter rights concluded the issue of whether the applicant's charter rights were violated was justifiable, and called the application a positive rights case. And this is a key area where the judge made an error according to this Court of Appeal. So what are positive rights? I'm reading in the Center for Constitutional Studies, Positive and Negative Rights, July 4th, 2019. And is there an author? I don't see an author related to this article. It says positive rights. Oh, sorry about that. Um, Positive rights require the government to act in certain ways. The government must, this is a quote, must take hands-on approach to ensure that guaranteed positive rights are accessible to the right holders. And then it says that there was a heavy burden on the government by requiring that resources be allocated in specific ways and with limited flexibility. And then negative rights require the government to refrain from acting in certain ways. And then it says governments can respect uh, individuals' negative rights by doing nothing at all. So there was a positive and a negative rights. So that's the previous justice talked about uh, the application judge uh, determined that this is a positive case when it is not. Um, According to this appeal, the judge in this appeal. And it says in paragraph 5, quote, in all view, the application judge erred in her analytical approach. This is not a positive rights case. The application does not seek to impose on Ontario any new positive obligations to combat climate change. By enacting the CTCA, Ontario voluntarily assumed a positive statutory obligation to combat climate change and to produce the plan and the target for that purpose. Ontario was therefore obligated to produce a plan and target that were charter compliant. So they're arguing because it is um, what's the word? That because Ontario voluntarily made this legislation, they have an obligation to meet the um, um, Charter of Rights and Freedoms, Section 7. Um, and then still in paragraph 5, the application judge did not address whether Ontario failed to produce a plan and target that was charter compliant in accordance with the statutory mandate. As a result, the Section 7 and 15 charter issues raised by the appellants remain to be determined. And then I'm going into paragraph 6. The interveners raised relevant, important issues that were not determined by the application judge. And then some of them were not in the notice of application. So they're saying that they might have to make a new notice of application or amend the notice of application. Some of the things that were brought up is whether the target breached charter rights of Indigenous people in Ontario and or Section 35 rights under the Constitution Act 1982. And is Section 35 included in the Charter of Rights and Freedoms? No, it doesn't look like it is. Section 20. So I'll have to pull that up. But it's section 35 is um, there's a duty to consult. Let's see. I'll pull that up. Section 35. So section 35 of the Canadian Constitution says the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. In this act, Aboriginal people of Canada include the Indian, Inuit, and Métis people of Canada. And I'm reading from the act itself. I'm not using which doesn't use appropriate language. For greater certainty in subsection 1, treaty rights includes rights that now exist by way of land, claims, amendments, or may be so acquired. And notwithstanding any other provisions of this act, the Aboriginal and treaty rights referred to in subsection 1 are guaranteed equally to male and female persons. So that's the section 35 of the act. And I found this on Indigenous Foundations .alt.ubc.ca. And then there's some other things that were mentioned, including best interest of the child principle, and the recognition and impact of certain unwritten constitutional principles, including environmental sustainability. And then in paragraph 7, the appeal was allowed, but they declined to decide the application and to make the orders. They say that the court was not well placed to determine whether the declarations and directions sought should be granted. And then in paragraph 8, the questions that must be determined at a new hearing. So they're saying that there must be a new hearing. Before the same or another justice of the Superior Court. And then there's some background. Let's see. It says I have 6 minutes left. So I might quickly go through this so we can look at some of the other items. There's some. Oh, I just want to check. There's a summary of legislative and evidentiary background. There's climate change legislation, international conventions, and uncontroverted evidence of harm. This is going back 1992. And then they talk about the Paris Agreement. And then in paragraph 10, it says Article 2 of the Paris Agreement calls on signatories to hold the increase in global average temperature to well below 2 degrees Celsius and to pursue efforts to limit the temperature increased to 1.5 degrees Celsius above pre-industrial levels. And Canada's original target was set at 30% reduction from 2005 greenhouse gas emissions by 2030. And then it says 2022 Canada announced a target of 40 to 45% reduction from 2005 greenhouse gas emissions by 2030. And then the application judge accepted the export evidence and found, this is in paragraph 2, that warming in Canada is on average about double the magnitude of global warming. Deaths in Ontario are projected to increase significantly, and if global temperatures rise above 1.5 degrees Celsius, heat waves are increasing in frequency. Climate change has increased the burden of certain infectious diseases. Climate change will increase the frequency and severity of wildfires in Ontario and across Canada. And climate change will increase flooding frequency and magnitude, etc. And then there's further findings. There's a disproportionate impact on young people and Indigenous peoples. Children are more sensitive to heat. Indigenous youth face particular mental health challenges due to their strong ties to the land. Loss of traditional food and cultural practices is impacting Indigenous people's mental and physical well-being. And another finding is it is indisputable that as a result of climate change, the Appellants and Ontarians in general are experiencing an increased risk of death and increased risk of security of the person. The CTCA did not prescribe reduction targets, but requires Ontario to do so. Let's see. And then they're saying that Ontario would have to reduce its 2005 emissions by approximately 52%, which is 22% more than 30% of the target by 2030. And this is in paragraph 23. So the application judge, while finding that there was justification in bringing this forward, agreed with Ontario that the court did not have institutional capacity and legitimacy to determine Canada and Ontario's fair share of the remaining carbon budget, and declined to address the appropriateness of relief sought. And then those issues. And then, so the plaintiffs, the appellants, all claiming that there was a mischaracterization of the court case, because they're not seeking positive obligations to combat climate change. And that they're saying that the target, the Ontario government set a target that commits the province to a high level of greenhouse gas emissions that will cause imminent harm to current and future generations of Ontario, and that Ontario is discriminating against youth and future generations on the basis of their age by forcing them to disproportionately bear the brunt of undisputed climate harms. And in paragraph 30, it says Ontario argues that the application judge was correct to dismiss the application and to conclude that Ontario's target was not unconstitutional. Ontario argues that the central issue raised on the appeal is effectively how the plan to address future adverse effects of global climate change, which is not a justifiable question. Um, so, and then it says, this is the appeals court. In all view, Ontario's framing of the appeal focused too narrowly on the question of remedy and fails to address the question of whether the application judge erred by characterizing the application as a positive right case, rather than acknowledging that Ontario had undertaken a positive statutory obligation to combat climate change. They've voluntarily assumed a positive statutory obligation under the CTCA to combat climate change and to produce the plan and target. The question is whether the application judge should have considered whether Ontario's alleged failure to comply with the statutory obligation violated the appellant's charter rights. And then, so the target was falling short of scientific obligations. I recommend reading paragraph 35, or the section called Positive Obligations versus Statutory Obligations. I don't have time to read through that, but there is they do talk about the difference. And in section 7, there's a two-step process, and I also recommend reading, I just have to find it. Section 7, life, liberty, and the security of the person. And then on the Government of Canada, justice.gc.ca, there's some analysis. I recommend reading that if you're interested in going deeper into this topic. There's a lot of information that I can't cover in half an hour, but it is interesting. It talks about previous court cases and analysis that have to be done to determine whether there is a total rights violation. But I did say I'll talk about like some of the other court cases, so I'll go to. So I want to look at some of them. There is a report, Global Climate Litigation Report, 2023 status review. This was referenced in the Eco Justice article, news release. I'm trying to avoid BBC, so I looked at an article from Eddie, which says High Court deems UK government's climate plans unlawful for the second time. The High Court declared that the government's plan to the government of the UK. This is before the Labour government came to power, and they determined the government's plan to tackle climate change and decarbonize the economy is unlawful. And then they mandated that the government revise its approach to net zero emissions. It didn't reduce greenhouse gases enough. And then there was the human rights. This is an article in the Guardian. Human rights violated by Swiss inaction on climate. ECHR rules in landmark case. The European Court of Human Rights. And then they ruled that Switzerland has violated the rights of a group of older Swiss women to family life. And Switzerland failed to comply with its duties to stop climate change. And then there was an impact on women or elderly individuals dying from excessive heat. And I think that was everything that I plan to talk about today. Don't have time for anyways. And I hope that you enjoy the rest of your day. Oh.